Hello, everyone. Welcome to the latest installment of our Integrating Doctrine and Diversity series. I am Michael Donnelly Boylan, he, him. I'm the Associate Dean for Enrollment and Strategic Initiatives here at the law school. And I'm going to begin this session like we begin everything here at Roger Williams University School of Law with our land and labor acknowledgement. So as we begin our program today, I want to take a moment to reflect on the lands on which we reside. We are coming from many places, and we want to acknowledge the ancestral homelands and traditional territories of indigenous and native peoples who have been here since time immemorial, and to recognize that we must continue to build our solidarity and kinship with native peoples across the Americas and across the globe. Roger Williams University School of Law is located in Bristol, Rhode Island, and so we acknowledge and we honor the Narragansett and Pokanoket people, as well as Soams, the original name of the land on which our campus resides. We also acknowledge that this country would not exist if not for the free enslaved labor of Black people. And we recognize that the town of Bristol and the very land on which our campus resides has benefited significantly from the trade of enslaved people from Africa. The economy of New England, of Rhode Island, and more specifically of Bristol, was built from wealth generated through the triangle trade of human lives. During this time of ongoing national reckoning with our history of slavery and the disparate treatment of Black people, we honor the legacy of the African diaspora and the Black lives, knowledge, and skills stolen due to violence and white supremacy. As we gather here today, the movement for justice and liberation is building in our country, yet many are still being met with violence and even being killed, while other people in our country actively work to stand in the way of progress. As upholders of justice, our hope is to become agents of change for members of our society who have been met with violence, physical, mental, and emotional violence, through our privilege. And as upholders of justice, we believe that our students, who soon will be practitioners of law, can be, and already are, agents of change as well. With that, I introduce Nicole Dyslewski, who will be leading our panel today. Thanks, Nicole.
Thank you so much, Michael. I really appreciate that, and I really appreciate everyone being here. Um, I'm really excited to talk today. Um, this is Unraveling Equity, the Effects of Anti-DEI Legislation on Academic Law Library Workers, which is a really long title. Um, as the true librarian that I am, I wanted to start by sharing two resources that have helped me research and understand the breadth and depth of what I will today call anti-DEI legislation. I think that's a catch-all, and it might not always, it might be over-inclusive and under-inclusive at times, but it's what I'm choosing to go with today. Um, so the first the tool that I want to point out is the CRT Forward Tracking Project at UCLA Law, which identifies, tracks, and analyzes local, state, and federal measures that attempt to restrict access to truthful information about critical race theory, race, and systemic racism. It has a map and also a database which displays 861 anti CRT efforts introduced at the local, state, and federal levels. And I think Chelsea is putting the link in the chat so everyone can see it. This tracker allows you to filter by type of institution like higher ed and by prohibited conduct like teaching or curriculum or book banning. Additionally, the Chronicle of Higher Education is tracking what they call the dismantling of diversity, equity, and inclusion efforts. This tracker collects changes that public colleges and some private colleges have made since January 2023 as a result of legislation, orders, or other state level and institutional level actions restricting diversity, equity, and inclusion efforts. Um, so this is a topic that is near and dear to my heart. And I think it's a topic that all law professors and law administrators and staff members should be paying attention to. This is not just a library problem or a library issue. This is a democracy problem. This is a truth problem. This is an equity problem, and it's an information problem. Anti-DEI legislation or policies can take several forms. It can be the banning of critical race theory. It can be the banning of certain books or library materials. It can be the elimination of jobs for DEIB professionals. It can be changes to our hiring practices. But beyond the specifics of the legislation or policies in each state or town or institution, it also can come in the form of fear. Fear that more changes are coming, fear of saying or doing the wrong thing, fear that we may be moving backwards and not forwards, fear of losing our jobs, and most importantly to me, fear of even talking about DEIB issues, issues of identity, issues that impact all of us, and issues that are real and personal and that matter. And the people speaking here today, which you'll meet in a few, they're near and dear to my hearts too. They're trusted colleagues who have experience in law libraries and are willing to share their experiences. Um, so let's kick off with Sarah. Um, Sarah Lambden, besides being a friend and trusted advisor to me personally, is the deputy director of the American Library Association's Office for Intellectual Freedom. Established in 1967, the Office for Intellectual Freedom is charged with implementing ALA policies concerning the concept of intellectual freedom as embodied in the Library Bill of Rights, the association's basic policy on free access to libraries and library material. Sarah, can you please introduce yourself and describe your background and, set the tone, starting on a global scale, not just focused on our law libraries, but can you share the ways in which libraries are being impacted by anti-DEI legislation and book banning laws?
Yeah, hi. It's so great to be here, and it's so cool to see so many like old and existing, enduring law library friends. Yeah, I just want I always feel the need to disclaim this. This hair, I was sick last year, lost all my hair. It's growing back. So I don't know. I always feel like disclaiming, like I didn't, this haircut chose me and I love it because it's hair. But let's talk about, yeah, what all the kind of wonderful introduction that Nicole gave us about how these kind of anti DEI and CRT and I mean, frankly, just other types of censorship attempts have impacted libraries. I don't, so I've been working at the American Library Association's Office for Intellectual Freedom for 6 months now. And when I first came to the Office for Intellectual Freedom, I tried to kind of keep my expectations in check. Like I'd seen stuff on the news about censorship and about, the legislation that Nicole is describing, but I didn't want to be hyperbolic. And what I found actually now being inside of the Office for Intellectual Freedom is not only that there is no level of hyperbolic, like there is no hyperbole. It is happening everywhere in every county, in academic libraries, in public libraries, and in school libraries. I can't tell you all how much I've learned about public and school libraries and school boards and library trustees, boards and associations, friends of the library associations, because all of these gears are being mechanized in ways that have not, we've never seen anything like this to this extent before. And part of it is because of the help of and kind of the grease of social media in the gears, making things viral and making it very easy to perpetuate these kinds of calls to limit, DEI curriculums or CIT curriculums. So I know that everybody else has a lot more to say about particularly law schools, law libraries, and academia. But what I will say as somebody who's working with kind of libraries across the spectrum is that in my work, I really don't differentiate between these anti-CRT and anti-DEI things that are happening in academia and and the kind of LGBTQIA and other censorship that we're seeing in school and public libraries. And that's because all of these are fundamentally the same things. They are efforts from a small group of people to impose their viewpoints and access to only materials that they deem appropriate on entire communities, rather whether it's an academic community, a school community, a local community with the public library system. It is all efforts to chill certain types of speech, to shame certain types of stories, and to erase certain types of communities and people. And in that way, these efforts are, while they look very different in an academic library than in, an elementary school library, they're fundamentally very similar, and tend to be brought by similar entities, organizations, and interest groups.
Thank you so much. I appreciate the seriousness that your office deals with this and the way that you presented it, because I think it does a good job of sort of setting the tone as we move into specifically talking about law libraries. Next up is Amanda. Amanda, can you please introduce yourself and describe your background? And based on your experiences, can you share how law libraries are impacted by anti-DEI legislation and book banning laws?
Sure. So I'm Amanda Watson. I've been in law librarianship a long time, over 20 years now. I am currently the assistant dean for law library and information at Harvard Law School, but I just recently was the director of the library at the University of Houston in Houston, Texas. And so a lot of my knowledge about legislation comes from there. But something you said too, Nicole, when you were talking about legislation or policy, I don't think in New England we can feel like we don't have policies written and unwritten that also impact our collections. And so honestly, we can speak about both of those things. Obviously Texas is famous in the bad way, infamous for some terrible legislation, which has impacted our universities, colleges, and also our library collections. In particular, there is a law in Texas that if you loan a banned book to a minor, you can be held criminally responsible. We have a similar law about helping someone get an abortion. And so we had to figure out what we were going to do about this, because we weren't going to stop loaning books that we felt were critical to the study of law. How can you not talk about race and law like you get to the Constitution? These aren't, a subject you can just skirt. So we decided that since sometimes students can be under 18, we needed to have a protocol in place. And you and I talked about this once, that a supervisor would be called if a minor was trying to borrow a banned book so that our SARC workers couldn't be arrested. And it may seem like a silly thing to do, but it weighs really heavily on your mind in these states. Like, how do you keep your collections diverse, but how also do you protect the staff of your library who certainly aren't like signing up to be arrested? So yeah, what else is helpful?
I just think it's really interesting how you sort of said that like the lending of these books is criminal in the same way, not exactly the same, but analogous to like providing an abortion or
Yeah,
abortion
yeah.
care. And when you think about people who choose that profession, there's a level of danger that you sort of know about. But the idea is like no one, and I think Josh will talk about this more, but no one goes into being a circulation worker at a law library thinking they're going to get arrested for doing what is, in essence, their job, and it's something that their institution or the people with library degrees at their institution believe is ethical.
Mm. Yeah, I mean, I think there is something in that a lot of librarians do, I think, hold dearly that we're sort of like public libraries are the most punk rock thing we still do, or, like we are sort of on the front lines of democracy. I've heard people say that, and I think that's all can be very true, but it really feels different when you are figuring out how the bail bondsman works. And in Houston, where I was previously, they were very upfront with me. They're like, if you get arrested, you will likely spend the night in some sort of holding area. That's just part of being arrested here. It's just so busy and so big, you probably won't get out the same day. So they're really, I mean, that's scary. It doesn't matter how ready you are to do it. It's still terrifying, right? I'm not really someone who's like, yay, prison. So I think it is essential and crucial though to a lot of people's lives. And we see, in the queer community, in my community, we see the suicides that happen when people don't understand that life is not always going to feel like this. I mean, these are very serious things. And so I do think it's the same as, helping people get, medical care they need, helping people get any type of resource they need. And we know that libraries they played pivotal role in my own coming up. And I can't imagine that they don't still for so many people, just to see themselves on the shelves and know that that they're normal and okay. And that, there are people there for them. Yeah.
Absolutely, like that is crucial to our missions.
Yeah.
That we are that safe space or that third space. Like we are not your family members, we are not your professors. We are this other thing which
Yeah.
supports the mission of your professors and the institution, but is also on purpose, has a different vibe, has a different, we usually have our own mission statements, our own policies, our own collection development policies. And so it is really important to respect that and honor what libraries mean to our country and our democracy and our patrons. The other thing I think I know, but I just want to make sure other people hear, the institution that you were at, was it particularly diverse?
Oh, so Houston's one of the most diverse law schools in the nation and has been for many years. It also, I think, very famously, accepts students who are not legally in the country. And I think that's very important to who they are. Houston is an incredibly diverse city, and our students, represent that population. And I think it's important for people to think about we go into these things, you have to understand what your protections are and what your protections aren't. And I often hear people talk about academic freedom in a way that tells me they don't actually understand what academic freedom means. And they really need to be careful that what is defined as academic freedom not only applies to them, but applies to the work they're doing. And so one thing I found myself in is I was a tenured faculty member at Houston, and I did enjoy academic freedom in my writing and teaching, but not in my developing of the collection or policies around the library. And so I think, it's just something to really be aware of and to work with general counsel or whoever you can to try to get as much policy and protection as you can get.
Thanks for sharing that. And the people who are doing the jobs aren't necessarily always, they don't necessarily always have tenure. So they might have like
Right.
no academic freedom in that sense.
Yeah.
And the move to sort of deprofessionalize us, is also impacting these issues.
Absolutely.
At least
Yeah.
in your scholarship and your teaching, you were still able to have some measure of protection.
Yes, I just published a collections article where I talk about decolonizing the stacks. I'm certainly on a lot of websites, Nicole, but nothing came from my institution about doing that. But I think even at Harvard, I am a staff at will employee, and I definitely know I have to like follow the line or I could easily be let go, right? So it's a different it's a different stack of rights, but I wouldn't necessarily say like it's more robust, right? So everybody just needs to be aware of their own situation as they're, fighting this fight and making the best decisions they can.
Thank you so much, Amanda. I'm going to move on to Nikki, but I will be back. Nikki, can you please introduce yourself and describe your background? And based on your experiences, can you share about how law libraries are impacted by anti-DEI legislation and book banning laws? Oh no, Nikki, we can't hear you. All right. Well, Nikki is going to work on that, and I will come back to Amanda. Um, just as long as you brought up sort of the collection part of it. Amanda, can you talk a little bit more about how the laws or sort of the fear behind the laws are impacting law library collections and purchases and potentially legal scholarship, which relies on law libraries to support it?
Yeah, I think it quickly became clear to us that we had to have endowed funds for certain collections so that they could be protected. We didn't have a lot of endowed funds at Houston. It's a younger law school, and there just wasn't a lot of that type of money. But we were very fortunate to have a donor's family stand up and offer us a small collection of materials and a little bit of money to go with it so that we could continue to collect in that area without fear of spending state funds in a certain way. And in Texas, strange things like this had happened before. One year it popped up that we had to have all of our vendors sign a pro-Israel pledge to be able to do business. I mean, this is not like an unusual thing for Texas to throw us a curveball as far as like, this is how we're going to do business with sellers. So I think the big thing is like, how are you going to pay for it? Are you ready to pay for it? And is your decision protected? And then, yes, of course, that spills out to our scholarship. If not, our faculty scholarship, where they can pay for their own monograph, to our student scholars, right? Who are feeling very like pinned in by the resources they have and what they can do with them. And I think many people's collection development policies could also be under similar scrutiny. I won't speak for Houston. In some ways, I don't want to like expose their own methods of how they've dealt with this, but I think people have to be very careful about the wording and what they say, because we know that people were like searching websites to try to find language to then challenge and attack, right? So it gets difficult to figure out how to serve without being so obscure that your audience can't find your materials anymore, but also you're protecting yourself from people who are simply searching to try to sue you. Right?
Thanks.
Yeah.
Nikki, are you here? We still can't hear you, Nikki. All right. Don't you love when this happens? This is like my biggest nightmare. But I will keep going on until we get Nikki back. Josh, could you please join us? Unlike Amanda and Nikki, Josh has not worked in an impacted library, but Josh is my go-to expert on all things related to curriculum and to circulation and access workers. Um, Hearing about the climate of fear described, and sort of based on your deep knowledge of working in circ and access services, can you share about how these laws may be impacting these workers? For example, at many libraries, these workers may be poorly paid, be working several shifts at different libraries to pay their bills, or be student workers. How might working in this fear of doing the wrong thing and running afoul of these rules or policies or legislation be impacting our library workers?
Thanks, Nicole. And yeah, I've been working in access services for a long time. And I think as I ponder this question, I've been thinking about like a long time ago, the things that kept me up at night were related to like the water pipe breaks in the ceiling. And then it became the active shooter. And then it became the person overdosing in the men's room. And then it became these sort of questions about book challenges, people secretly recording or openly recording library staff on the front line. Some of that is motivated by someone's very sincerely held beliefs, but sometimes it's just that they're trying to build a social media following, and this is a good way to do it. If you've not heard of the concept of the First Amendment audit, If you work in a library, you should probably go look that up and find out more about it, because if your staff is not trained to deal with it properly, you can get yourself into a pretty big pickle pretty quickly. I think that, like, in all of this, I did a lot of outreach over the past 6 months to librarians in affected areas of the country. You know, I'm a queer guy, but I'm also a guy, and I'm in New York City and like don't deal with these things as much on a day-to-day basis. But I was really shocked at how much of a chilling effect these laws have had on our colleagues around the country. Access services people talk about hard stuff in shop talk all the time, like all the time. That's what we talk about. It's like just really kind of challenging things that come up and really concrete ways that people have figured out how to respond to them. This is something that basically nobody responds. And the only way that I was able to start to get some conversations flowing was to start making some phone calls. And really it was just sort of people telling me things like, I'm worried, even people who worked in private institutions where the law's reach is not, it's more abstract, worried about their future employment prospects if they were to end up in a job, in an applicant pool for a job at a public sector library, or even just people finding something that they wrote or said or tweeted that can then be used against them in any context. And so when I think about the effect on frontline workers, I think a lot about how, unfortunately, a lot of our frontline workers are not so professional librarians. They're not credentialed folks. And some of them are student workers. Some of them are part-time. Some of them are on 9-month contracts and things. They're very contingent. It's Amanda said, we're at-will employees, which is sort of a reality. I worked in a public university for a long time, so I was a union employee, which is a very different experience. But at-will employees who are at risk of losing their jobs if they piss off a patron is a very precarious place to operate from. It's very difficult to make good, solid, intelligent, reasonable decisions in the heat of the moment when you're afraid. And you can't, as a manager of frontline workers, it's hard to, you can't prepare people for everything that could come up. And sometimes the trainings that we try to do to help people be prepared actually make them more anxious. I saw that in a big way, 10 or 15 years ago when active shooter trainings were happening all the time. And it was really, people were went from something that they needed to think about to something that they were actively afraid of on a day-to-day basis. I see that we have Jessica says that they had a First Amendment audit recently. Yes, they're scary. I think that what I'm thinking about the First Amendment audit situation, this is where somebody goes in with a video camera recording the library. They're recording patrons in the library, they're recording staff, and basically they're trying to goad the library into telling them, you can't film here. And then they can lean on their First Amendment rights in a public space to film. So, and it is just trying to they can then edit this into a really fun social media video that will get lots of engagement. And I'm thinking about people in states where there are strong anti-DEI laws on the books, using this same tactic to try to catch out unprepared frontline workers. And Amanda said the same thing that I've always said. It's get me, I'll come out and I'll deal with whatever. And that you were telling and these are the things to come out and get a supervisor to help you. You're not paid enough to deal with this. But in the heat of the moment, when you're afraid, that's hard to do. And so you've got frontline workers who are in a state of precarity, and they often have very little input on library policies or library decisions or library protocols. And they're perhaps working during times when there is nobody else there. And it's a scary situation. And I think that chilling effect that access services staff who tend to be really good about being each other's support systems on difficult stuff are afraid to talk about this because of how sort of toxic it's become. It worries me a lot. And I think it's really an area that this is creating a lot of exhaustion for our colleagues in the front of the house, not just in the front of the house. And Nicole, may I offer one last thing before I shut up? And DEI work, DEI centers, attention to diversity, equity, and inclusion have created a lot of really wonderful inroads for non-credentialed library staff to start to be treated like professionals at work. I've seen that it's been really meaningful that libraries have strategic planning to decolonize their library, and that includes things like flattening hierarchies and improving career pathways for their colleagues who are in non-MLIS positions. And that's amazing and wonderful. And I worry a lot that this sort of culture of anti-everything really risks that kind of falling behind, that those doors have been opened, they're sort of getting shut again, and it worries me a lot.
Thanks for sharing, Josh. I'm kind of like where you are. Like I spent the last, year or two looking for things, listening to things, talking to people, and waiting for the rest of legal education to jump up and act shocked and help us. And I think that there's a culture of, the library supports the institution, and not always the institution needs to support the library. And then I started doing some work locally, which I'll talk about in a minute. And I got scared. I got scared for all the people who librarians generally are underpaid. The people who work circ are often making close to minimum wage. If some people are unionized and have union protection, maybe the unions haven't had to deal with these issues before, because unless you're like sort of always just a library union, you might not had to. And even if you have, these are novel. And I just think people are scared. And when they're scared, we're less able to kind of put up the type of book displays and hold the type of events and do the type of meaningful work that I think Amanda talked about, that is open and affirming and inclusive to everyone, regardless of your sort of immigration status, regardless of your sexual identity or your own journey. We are embracing you. And it is very hard for us to embrace you if we are afraid of losing our jobs. And that is all happening, in my opinion, like sort of away from what everyone's paying attention to. And so that's kind of why I wanted to do this. One is because Nikki and Amanda have experienced this firsthand, and both are now in positions where they're able to share. But also, I just want us to all talk about it. What I want you to do is talk to your faculty about this, and I'm not saying the librarians, we have enough going on. I'm saying anyone here who isn't a librarian, can you talk to your other faculty members about, did they know this was happening? And did they know that their librarians were having to consider these issues and maybe concerned for their jobs? Have you talked to administration about what the plan is if someone does get arrested? Or will the university be paying for an attorney? Who's going to bail the person out? What is the process? And is there support in place to emotionally help people who are being faced with this for the first time in their job? So thanks, Josh. I will come back to you again. Nikki, I want to do a check-in. Do you have any audio yet? Well, that sounds like a no. All right. Nikki is still working on her audio. I see there's probably an IT person with her. So I'm gonna go back to Sarah. Sarah, this isn't just a red state issue. And it is not just something that people who work in public libraries should be concerned about. But in Rhode Island, we've been working to change our laws and protect our librarians. And Chelsea's gonna share a story in the chat. Specifically, last year we were advocating for a bill H 7575, which offers an affirmative defense against prosecution aimed at library, school, or museum employees on the basis of obscenity. Right now, we're one of the few states that offers no protections in the statutes. So if a school-aged library patron borrowed a book from a library worker, took the book home, and their parents objected to it, their parent could call the police and try to have the library worker arrested for having violated the obscenity laws. Sort of in the conversations about this, in the same way someone could do the same thing if somebody had given their child pornography. Like, it's the same obscenity laws, and there's no protection written into the statutes for library workers. So our professional expertise as information professionals and our thoughtfully curated collections are not protected legally from prosecution in this way. Can you share a bit about the landscape on this issue, and has anyone ever been arrested for this? Has this happened?
Yeah, that's a great question. And that's one of the things that we're seeing a lot of, especially now that state legislatures are back in session, are getting back in session. We're seeing a lot of pre-files for both laws that would criminalize librarians, or laws that somehow try to incorporate concepts of obscenity into punitive or censorship, punitive laws or censoring laws that are imposed on school public academic libraries. So interestingly, I think one thing we've all come to, and that Josh did such a great job of explaining, is just kind of how much of this is intimidation. And these laws are definitely, to me, the pinnacle of intimidation, threatening to criminalize librarians for just doing their jobs. And you were like what you said about Rhode Island versus other states. A lot of states already have built-in affirmative defenses protecting educators and librarians from being subject to obscenity statutes for their work. So in some states, they're trying to strip away those protections. And then in other states, they're trying to actively criminalize libraries and librarians for sexually explicit materials, or especially in the case of academic librarians, looking to defund academic libraries and strip funding away from academic libraries, which I think on a federal level is also kind of in play right now. So one of the things to know about obscenity laws, and one of the things to know that we go back to time and time again, because it's so well founded, is that the First Amendment exception for obscenity is very, very narrow. There is the Miller test for adults, and then there is the Ginsburg test, which is just a reasonable child standard for the Miller test for school-age children, for minors. And both of these tests require that, it's remember what if you went to law school, you learned about, the prurient interest, patently obscene. And then one of the most important things to keep in mind is that for a work to be considered obscene, under most penal code statutes, it has to be, for a work to pass the Miller test, it has the entire work has to be pornographic, has to be obscene. And there are very few works. One thing that we always note is that most libraries would never even acquire, a specialized library that maybe specializes in sexual materials might collect that type of material. No libraries collect patently obscene material and material that would pass the Miller test. So generally, we try to encourage librarians to be aware about how these laws serve to intimidate, but also to kind of give them hope that the likelihood that they would really be criminalized it's hard. It's really hard to prove that something is obscene.
Can I just jump in? Because I've thought a lot about this, but
Yeah.
the Miller test is only going to come up um, in a court proceeding, um, or possibly at the level of the prosecution, but it's not going to stop you. I mean, but you can correct me if I'm wrong. It's not going to stop you from being, from the process Amanda talked about. It's not going to stop you from being arrested. It might not stop you from having to stay overnight and being arraigned. And like in Rhode Island, we have a limited place where the cops who arrested you could also be are also acting in a prosecutorial function. And a prosecutor, because of political reasons, might also feel like pressing forward with the case. So the Miller test doesn't sort of come up until later in the process.
Right.
Am I right about that? Do I have that straight?
You're absolutely correct. And we have there are stories that can be told about, members of my office on the phone late at night with law enforcement, making sure that librarians are not being wrongly detained, wrongly arrested, etc. So yeah, you're absolutely correct. The tool of intimidation is still definitely there and usable. And the threat of arrest is there. And earlier I dropped a link to Lawyers for Libraries. One thing we are seeing across the board is that in situations like these, it really helps to have city and local attorneys that are well trained in the law, so that they can immediately kind of dive in and work with local law enforcement and clarify, the legalities involved. So if you know lawyers who would be interested in doing that, or law librarians, etc., feel free to kind of to check that out, to join in that effort. But yeah, one of the problems that we're seeing is oftentimes, despite what the law would say, even in states with affirmative defenses, when you're in a school board meeting, when a law enforcement agent has come to your school or your public library, etc., in the moment, like Nicole pointed out so well, that things happen that don't comport with constitutional law concepts, and we're seeing that more and more. So we're trying to staff up. We're trying to get as many attorneys in the game as possible, just to be able to intervene and warn about the expense of litigation, the trouble with doing things that are not legal. Yeah, because on the ground it's
you might not know the answer to this question, but in my state, I've only heard of one library director who said he would in fact pay for the lawyer, or the library would pay for a lawyer if someone was arrested. Do you know if libraries have policies on whether they're going to pay if someone gets arrested, rightly or wrongly, in this situation?
Yeah, that's a really good question, and it's a variable. We always say that policies are like the best policy. Libraries, if you are in a library, are a friend of your local library, you might want to check in on that and make sure that if there are any legal challenges that come up, there is some sort of funding, there is some sort of guaranteed support. And if not, you can reach out to the American Library Association. We also have a fund called the Merit Fund. If you find yourself in a situation where you are going to have to spend money on something related to any of the things we've talked about today, we do have funding for that. We have a special fund that will support you. We'll support you. I don't want to, it depends on, what the level of support necessary is. And we're also looking to help provide lawyers for localities that don't have that kind of protection. But definitely, I advise, especially in the climate we're in now, all libraries should be ready and prepared to have some sort of legal counsel. Oftentimes, the legal counsel will end up being city or local attorney, or an attorney with a specialty in municipal law. Because we've seen instances where a librarian will be doing something that in the moment seems like absolutely the right thing to do, and objectively might be the right thing to do, but then there's a lawsuit filed against the library. That happens a lot. And in a lot of situations, it does seem like that's the setup. Like they do things to provoke you into doing something that will violate some sort of First Amendment right that they have, and then they'll file a lawsuit. That's one of the things that these entities are looking to do, because it really does drain municipal funding, drain library funding, drain school funding.
I think you made a really good point that I just want to amplify in there, which is librarians, in my opinion, are not always the best advocates for libraries. We are constrained. I know a lot of librarians are afraid of speaking up because they can't afford to lose their jobs. We are sometimes more passive, or just not advocacy might not naturally. And so to the non-law librarians on here, please advocate for our profession. Please show up for the hearings in front of the legislatures. Please do the work of advocacy also, because not we're not best positioned to do it right now, for any number of reasons. And I think, we could use some very vocal friends who see the value in what we do and want to support us. I want to go back. Nikki, I think you're here. Nikki, are you here?
I think I'm
I have
here.
some bad luck.
Am I
Oh.
here?
Yes, you're here. Welcome, Nikki.
Okay.
So can you talk a bit about who you are, what your experience it is, and how you have seen law libraries impacted by DEI legislation or anti-DEI?
Hey, everybody. So up until 6 months ago, I worked at North Carolina Central University, and now I work for a firm that doesn't like Zoom, so that's why I'm having all this. So I was the director of the academic law library at one of the 6 HBCU law schools in the country. Not only was I the director, but I'm also a graduate of the law school, and I have worked at that law school for most of my career in law librarianship at this institution. So I think this topic is really kind of coming full circle, because when you look at one of the 6 HBCU law schools in the country, when you're talking about anti-DEI, it's kind of oxymoronic, in my opinion, right? Because North Carolina Central University School of Law was created when the North Carolina General Assembly didn't want Negroes at that time, African Americans, to attend the University of North Carolina at Chapel Hill. So because black students weren't allowed to attend the only other public institution in the state, North Carolina Central University was created. So this was their separate but equal option for Blacks who wanted to become lawyers. And I think it's really important that we have that in the background when we talk about anti-DEI, because essentially the law school was created from an anti-DEI perspective, right? Because in 1939, we didn't want to deal with it. We wanted to have a separate option. So fast forward, this law school was created and thriving, right? The law school has significant African American graduates, including Maynard Jackson, the former mayor of Atlanta, a whole host of it. But on the level that we want to talk about, most of the district court judges in the state of North Carolina are NCCU alumni. So you really want to look at that. And so when you come to North Carolina and you talk about these anti-DEI, policies that were created, in 2019, we had legislation that actually called for the creation of DEI centers and policies, right? So in 2019 and 2020, we were in the thick of George Floyd's murder, a whole host of equality and bringing everything up. Then you have the Supreme Court decision, which essentially says that race cannot be used as a factor, right? What does that do to to the mission and core of a school whose race is at its very existence, right? But then you move forward, in 2024, the University of North Carolina, following suit with Texas and Florida, and a host of other, states, they vote for the removal of DEI, and this vote is replaced with a new policy highlighting institutional neutrality, right? And so institutional neutrality, what does that mean? Like, especially when you have an institution that was created and supports African Americans, how can you support and move forward? I think the framework that they're trying to do is saying support the whole student. Well, you can't support a whole student when you don't see the student and you don't understand their background or can't discuss their background. And I feel like that's the most important part and critical part. I don't know how far North Carolina is willing to take this. As of September 1, there was a report back from all the institutions. The Chronicle of Higher Education has that outlined and what all of the state institutions, the state universities have done to eliminate LGBTQ centers, African American centers, et cetera, and to focus, and they're all focusing on, again, this institutional neutrality and not considering the students as a whole. I will say that one thing that, as I've taken a delve in the last couple of months, has revealed is that North Carolina's policies don't affect student organizations. So one of the things that you can do, and I know this is, but for my technical difficulties, we would have gotten a little bit more into this. What can we do is study your policies and look at your policies, because it doesn't prohibit student organizations from moving forward with examining some of these DEI initiatives still.
Thanks, Nikki. What you're talking about also, to me, implies the issue with the standards in 303. So if we have this anti-DEI legislation, or in some cases anti-CRT legislation or policies, and we have this sort of neutral institution, well, how does a neutral institution who is not going to talk about race satisfy the ABA standards for 303? And I haven't heard anyone who solves this problem yet. But I guess my question to you is, do you see us moving towards a place where we don't have HBCUs, or we defund HBCUs, or is there? Because to me, like if the mission of an institution, I'm not suggesting this obviously, but if the mission of the institution is so hampered, is this a next step for the legislature, or were there any conversations about that?
So that's my fear, and I come from a HBCU household. Like my husband is North Carolina A&T undergrad, and then NCCU Law School for his professional. And he is like, never in 1,000 years. I say, look at where we're going and look at what is happening and look at who's in charge. Again, something that I couldn't say, but from my employment, right? Look at the policies and who is being put in place and will be in place in 2025. Dare I say that will have a revolution? Absolutely. There's just too many African Americans will not stand for HBCUs. They're already suffering in a great deal, but I think that's across the board. Many small private HBCUs have already closed or are closing. But to protect our public HBCUs will be at the core and mission of, I think, almost every graduate of HBCU. I've been in North Carolina for 30 years. There are some proud HBCU alums, all over the country. And I dare say that we will fight you tooth and nail for that.
Well, that's great to hear. You brought a lot of hope to the conversation. This question is for everybody, but Nikki, I'll start with you, and then we can sort of
Mhm.
go around. Um, Speaking about the anti-DEI laws in Florida and Texas, Carrie
Mm.
Landry Thomas, the Associate Vice Chancellor for Equity Inclusion in Title IX at Southern University Law Center, a historically Black university in Baton Rouge, Louisiana, writes, the overall effect is to chill any efforts related to DEI by causing mistrust, chaos, and hostility. Anyone working in this area can attest this type of environment effectively ends DEI work in Texas and Florida and burdens DEI efforts across the country as more state legislators become emboldened to challenge the premise of DEI efforts. While Landry Thomas ends on a positive note, I personally am having a hard time seeing the way forward. Based on your experiences, what is the way forward? What might we expect to see in the next 2 years? And what effective strategies have you seen or developed to work in these environments and with these restrictions? Nikki, I'll start with you.
Yeah, my way forward is history. You can't anti-DEI facts and historical privileges. So any institution you have when the first African American student was allowed to enroll, that's at any PWI or public. You know, when were women allowed to attend your school? When did these events occur? You know, was there student engagement about a particular issue? So tell your story. So again, this is archive, you know, also about archiving. You know, when was the first African-American professor hired at your school? When was, you know, so those are not pro-DEI or anything. It's your history. So if you talk about your history, you tell your story tells itself. So now I can't hear you. Okay.
Josh, Sarah, and Amanda, do you want to jump on and also answer?
Yeah, absolutely. First of all, Nikki, that was so beautifully said. I love everything Nikki says, but that was brilliant. I think we have to be brave, and bravery means failure. You know, like it's okay. We tell our son all the time, it's okay to be scared, just do it scared. And so I think, you know, whatever our positions are, we just have to do what we can do and know that sometimes that's going to lead to things that people question and don't think is okay. And we just have to do our best and listen to our colleagues. So when someone as brilliant as Nikki Perry talks, then you get out your sword behind her and you fight for her. And I think that's what we do.
Thanks, Sarah and Josh.
Yeah, I also, Nikki, thank you. I've learned a lot from Nikki. I've been on a committee with her for many years, and I feel like there's been a lot of really good learning. And I think that's an important thing that we need to keep. And that's my point. I found some old statistics from the ALA. We don't have a lot of demographic information about library staff in general, but in 2011, there was a report that showed that credentialed librarians were showing ethnic and racial diversity to about 10% of their population, whereas library support staff were closer to 30%. And so I think it's really important when we want to make sure that we continue the work of building diversity and inclusion in our libraries, make sure that you are including your support staff in your library and giving them pathways to learn and develop skills and have a career path in your library, because they're already pretty diverse. And that we need to look at that and acknowledge it and make sure those people are being included as a group. So it's not DEI, it's just good management.
Thanks, Josh. Sarah.
Yeah, I totally agree. I think we have to ensure that our profession represents everybody and has everybody's voices. And I think Josh is right. Like, if we look statistically, we are not excellent at doing that as a profession. And I know that's something that in AALL was for a long time like a priority initiative. So we can't let that go to the back burner. And from my perspective, I'm going to try to answer the last question in the Q&A as well, because I think that that's kind of where we are. My role now is really just helping librarians with these issues. And so I want to help librarians, as many librarians as possible, because this is so prevalent right now. And I think a large part of that it is to stop being reactive. And a lot of it, we haven't had the chance to be proactive because this onslaught really started in earnest in 2022 and has been just fast and furious ever since. If you look at any graph, like the rise of like these types of initiatives is like, so we need to start being proactive. We need to proudly own the space, kind of what Amanda was saying. You know, we need to throw our swords into the fight. We need to start telling affirmatively the story of librarians and libraries and highlighting the importance of these institutions as cornerstones of democracy and access to information as kind of the linchpin that holds it all together. We need to be we need to keep making those collection development choices and those opportunities for every voice to be represented on our shelves, even in the face of these types of challenges. But I know that also requires us to build a community amongst ourselves, because it is really, really hard. So much of my job is listening to librarians tell their stories and trying to enforce the knowledge that they're not alone. Because when it happens to you, it feels very isolating and hard and scary and awful. So I think the more we can build community, both within librarianship and then in surrounding organizations, whether it's amongst our general faculty, if you're in an academic librarian, or amongst the student body, or your community or school district, if you're in a public or school library. So really, I think community and steadfastness will drive us through and help us take back the narrative on this.
Thank you so much, Sarah. My final thoughts are: librarians, you're doing a great job. Keep up the good work despite the stress. My real message is for the non-librarians. They're coming for the librarians. And these are your, statistically, one of your most trusted professions that there is are librarians, at least according to one study. These are people who come to work every day. And like Josh said, they deal with the plumbing in the building. And when it rains, they get out the trash cans and catch the drops. They're sometimes the first people in the building and the last people to go home. They're quieter than the rest of the campus. They know our students. They support our mission. They support our scholarship. They support our teaching. And I think we really owe it to them to pay attention to what's going on, and not just how it affects the policies, but how it affects the people who work in those libraries every day. So I just want to say thank you to the speakers. This is a really difficult topic to talk about. Particularly thank you to Amanda and Nikki, who formerly were not really able to talk about these topics, but now are in positions where they have left those jobs and are able to talk more broadly. Thank you everyone who attended. Sorry about all of the technical issues we had. We'll do better next year. And I will see you again in early 2025 for the next Integrating Doctrine and Diversity.